Good afternoon, everybody. Keith here. Hey, I wanted to talk to you today about the 10th Amendment and a couple words in that amendment there in regards to the language that we're using today and how to comprehend exactly what's going on. The use of the words that we have today are, for the most part, quite ambiguous. And the reason for that is because of the way that we construct what we're speaking. And when we are talking about the 10th Amendment and the powers that are granted to the United States, but not not granted to the states or whatever, the wording in the 10th Amendment in regards to the powers of the state and the United States, as well as the powers of the people. Okay, if you take a look at the 10th Amendment, it's going to talk about the United States, the states, and the people, as well as the powers thereof. And there's one little word in that 10th Amendment that makes a great deal of difference, and that is the word or. Just two letters, or. And so when we're talking about the powers delegated to the United States, or delegated to the states, or delegated to the people, that one word or means a big difference in those powers, because no state and the United States, both, neither one of them can have powers anything greater than privilege. While on the other hand, the people's power is rights, or liberty of rights. So when we're looking at the 10th Amendment and we see that one word, or, in relation to the powers that are delegated to each of those parties, the United States, the state, and the people, the powers in the people, and this goes right back to the institution of government to begin with, is that it is the liberty of the right of the people to institute the government to begin with. And therefore, it's the powers that are delegated to the state or the United States are mere privileges that are granted by we, the people. And that is only done by our consent on an individual basis. In other words, you can go ahead and grant them powers of privilege if you wish. I don't. I don't grant anybody powers, because I maintain my liberty of rights at all times, at all costs. Because the powers that I've been given were given to me by a superior authority known as natural creation, and not a fictional creation afterwards. And that's where we get this thing about the powers or the rights of the people, which are inherent and unalienable and common amongst all mankind, are antecedent to the formation of the state, the United States, any religion, any commercial entity, any construct of anything that we created after our creation. We have the powers of liberty of right, and then granted powers of privilege if those powers of privilege are upheld in good faith. In other words, if we delegate somebody to do our accounting and they're not doing it correctly, do we go ahead and keep allowing them to do our accounting and keep fucking our books up even more? Or do we take those powers away and give them to somebody else? Or do we take those powers away and do that accounting ourselves to make sure it's accurate? And this is the importance of the words that we're using. Even that one little word, or, makes such a big difference, and you have to realize what it's in relation to. Same thing with the word and. And when we talk about the word and, it's the same kind of thing. The word and denotes a similarity. Okay, so the powers of the states and the United States are that of privilege, and the powers of the people are that of liberty of right. And that denotes that they are different. The word "and" right there, in that context of use, means that they are separate. When you use them in conjunction, like I said, the United States and the states have powers of privilege. That denotes that they're the same because you're using the privilege as the denominator of the similarity. And then you use the word "and" again to finish that statement. And the powers of the people, again, denoting the similarity of the powers, are different in that they are right or liberty of right. So in the word "and," in the context that I've just used it there, I've used it in two different contexts within the same sentence, denoting both a similarity and a difference. So we have to understand that the words that we're using are very ambiguous in accordance to the construct of what we're using them for. In other words, the way we construct the words, put them in line. And they are lineal. Everything in life is lineal, circular, cyclical, subsequent to, antecedent to. And those are things, these are very important words that we need to start learning and comprehending, become cognizant of. Knowing, cognizant. And there's another good word, cognizant. Do you cognize something or do you recognize something? In other words, recognize. Do you recognize who you are when you look at yourself in the mirror? Or do you cognize because you already know and you keep that knowledge? Or do you have to look in that mirror to recognize who you are because you forgot who you are? So now you have to look in the mirror? See, the words are very important, and you have to understand the construction of them. I talked a while back on one of my posts, or a comment on a post about the letter mark, word mark, and trademark. And when you want to deal with a trademark, we're talking about signature, autograph, and mark. Okay, when you make a contract and you're illiterate of the words because you can't understand how to write them or read them, but you can comprehend what's being said verbally, you can do that contract without being able to write your own name by putting a mark. And therefore you've made a contract, an agreement to trade one thing for another, and then placed your mark, and that's your trademark. Okay? Now, when you use words, when you become literate and you're able to read and write those words, you have word marks that are made of letter marks. And it's just merely artwork. Everybody has a different artwork, and that's why they go to when they do authentication of sports members writing their autographs. You get an autograph football, you want to make sure it's an authentic autograph. There are letter marks, word marks, cursive marks, script marks that you use that are in your own art form, because everybody uses a different shape L or whatever. They slant it different. They slant it forward. They slant it backwards. They make it perfectly up and down. Some of them make it nice. Without any lines on the paper, they can make it nice and level. Some of them aren't quite that accurate, so it ends up being skewed, and they have to try to straighten it out. So you end up with words like this, sentences that aren't parallel. And that's all just artwork. Okay? And that's a recognition. When somebody is become cognizant of your signature, and somebody presents a signature to them to authorize or to authenticate, they recognize it, they recognize it. If they don't recognize it, it means it's not an authentic autograph. or not likely to be an authentic autograph. And so when we talk about this 10th Amendment, we have to understand that that one little word "or" makes a big difference in the powers in which it refers to. That one word in the 10th Amendment refers to the powers that are delegated to the state, United States, and the people. They're all three different. And the United States has privileges that are superior to the privileges of the states, but equal among all the states. And that's why all of the states have to follow federal guidelines, because their powers of, or their privileges of delegation of powers to the states is superior. If it were the other way around, we wouldn't have a federal government, because every state would be running as their own nation as they were originally constructed under the concept of separation of states. But then when the federal government was established, that's where the powers were belayed upon one organization to make sure that the powers of all the states were delegated evenly. And what people are forgetting is that those powers originally generated from the people's consent to be governed. If you do not have the comprehension of understanding that your powers are powers of liberty of right over privileges, then you're not going to understand. And that's why we have to understand the words that we're using. That's why it's important. Every one of these court documents uses 2, 3, sometimes even 4 different languages according to the art forms that they're using on them. Italics is different than bold. Bold is different than all capitals. Capitals at the beginning of each word is different than regular common English, which only uses the capital letter at the beginning of each sentence. Period. So understand the words that we're using, the letters that you're using, how they're constructed to form the words, terms, and conditions. Words are different than terms. Terms are different than conditions. A word is traveling. A term is driving. Driving is a term which is defined categorically with other words that make it a term. In other words, one who is operating, which can be used in many different aspects of life, not just operating a motor vehicle. Somebody can operate a kitchen just as well as they operate a motor vehicle. So when we put the word operate and commerce together, that gives us the term driving. The condition is that you have to use a motor vehicle in order to be driving. And motor vehicle is another term, again defined by the use. So again, people, I hope everybody understands, and the 10th Amendment is one of the most important amendments that we can rely upon in regards to this situation that we're in. You know, everybody thinks that First Amendment is almighty and powerful, and it does have a lot of power. I've gotten into a conversation here lately in regards to the separation of church and state. And when that First Amendment says that Congress shall make no law respecting the establishment of a religion or restricting a religion, that means that there's a separation of church and state. It's not saying it directly, but it's saying that there is a separation of church and state. And that comes from our founding fathers who had all different kinds of religions. Some were Protestant, some were Jewish, some were Catholic, some were Christian. And they all agreed that religion had no place. The church had no place in state affairs. And state affairs had no place in the church affairs. They were to be separate. And so that's why we have that first and foremost in the First Amendment. And it is a very powerful one. But again, that 10th Amendment shows that same separation between the state and the people. And that's the separation we have to understand. We have to understand that the people came antecedent before the formation of any church, any state, any kind of religious, any kind of a cult, sect, commercial entity, anything. Man came first. Period. And then from man came a fictional creation. And again, I want to refer to words. You know, somebody says the words that you use are coming from this dictionary, yet the words that this guy's using is coming from another dictionary. What if I'm using words that aren't defined in a dictionary because I have my own definition? I determine what the word is. You have to understand that. That's where the power is. In yourself. The power is the liberty of right over privilege. So that 10th Amendment is saying that there's a separation between church and between the state and people. Just like the First Amendment clarifies that there's a separation between church and state, the 10th Amendment clarifies there's a separation between the people and the state. And both of those amendments put together, might I point out to you here, is that there's a separation between church, state, and people. Understand this stuff, people. The words that we're using have to be our own words. We have to be cognizant of the words we are using ourselves as our own words, as we define them, as we artfully draw them, as we artfully create them up here and then transfer them to a literal sense on paper. And that's the fiction part of it. Because my words will never be your words. Your words will never be my words. Your truth can't be my truth because I haven't lived your life. And it's like this thing about I am. The words that we use have to be in present tense. We can't use words like I am a living being because that means future tense and past tense as well as present tense. We can't do that. That's mixing all three jurisdictions. You gotta maintain one jurisdiction at one time. So I am a live being. I wasn't living before, and I'm not living tomorrow. I'm live now, and that's that comment. I am. It's a present tense thing. I am, and nobody can rebut that. If you stand in a court and say I am, can the prosecution rebut that? They're going to look at you like that's stupid, because there's no way they can rebut that you are. But they will question, what do you mean? And that's what you get to. That's when you get to tell, well, I am here now. Where's the plaintiff fictional state? You know, I am live. Now I'm supposed to have this liberty of right to be confronted by my accuser, and that accuser has to be standing over there and has to be first-hand witness. So if the state of state is the first-hand is the accuser, first of all, how come they're not over there? Because this prosecutor over here is fired. He's not representing me. And if he's representing some fictional entity, then I'd like to see the court pass on any or accept any kind of subject matter jurisdiction, territorial jurisdiction, personal jurisdiction, whatever. I'd like to see them try to prove that they have attained that through a fictional entity. They can't do that. The only way they can do that, again, an attorney can only represent a corporation. So in order to bring a prosecutor for the plaintiff in, there has to be an attorney to bring the corporate fictional defendant in, and that would merely be the birth certificate. You cannot bring a living man in as a fictional defendant. And again, that's where when I go back to the stylization of the words and everything, whether it be italics or bold or all caps, whatever, the defendant is always a fictional person, unless you are in a common law court asserting your own jurisdiction under ecclesiastical law of common law. So understand this stuff, people. The words that we're using have to be cognized. Because if you think you recognize the words, You might be wrong. You might still be trying to recognize them because you may have once known the meaning of the word or, but somehow lost the meaning of the word or. But the purpose of this is that we have to understand the context of the ways they're being used. Is it being used as a word, term, condition? And this is why you got to get away from all the words that they want to use, such as creditor and debtor and guarantor and stuff. What words are they? Are those words or terms? See, I'm not a creditor. I'm not a debtor. I'm not a guarantor. Because I don't guarantee anything. I can't guarantee I'm going to be here tomorrow. I can't guarantee I'm going to be able to finish this damn video. I don't know. And I can only profess what I know. So, think about this stuff, people, and realize that the words you're using is what's harming you. If you're going to sign your name, if you're going to place an autograph, if you're going to place a mark on any document, you better know every word. You better be cognizant of every word on that document. Period. Plain and simple. So these affidavits out there, the never perfect affidavit, the remedy affidavit, these things, you can go ahead and read them all you want. 90 pages long, 60 pages long. But I guarantee you better know every word, term, and condition. Because if you're not cognizant of it, they will use them against you. Period. That Miranda rights, anything you say can and will be used against you in a court of law. Anything you say can and will be used against you in a court of law. Are they bringing us to a court of law? Nope. Because they can't. Miranda rights do you no good. Period. I could care less if they read me my Miranda rights. I'm not going to accept them. I don't have Miranda rights. I don't. Nobody has Miranda rights. The Miranda right says that anything you say can and will be used against you in a court of law. Well, if you're speaking the truth in a court of law, how can they use that against you? That kind of nullifies that Miranda rights. And that's where we get into courts of law in controversies of fact and law. See, when a cop pulls you over and he wants to give you a citation, first thing he's done is committed a felony by turning on the lights and sirens, declaring an emergency, which is not an emergency. Second thing he's done is he's initiated a contract without knowing that he's in it. Most of these cops out there are incompetent, ignorant of the law. They don't know the law. They just know their internal rules and regulations that they're supposed to follow according to the municipality, the county, or the state, or even the federal. They're all bullshit, every last one of them. So we have to understand this stuff and realize that when they're bringing this stuff, we have to understand exactly what's happening, word for word, term for term, condition for condition. If we don't, I don't understand. Do you understand these proceedings today? The only thing I understand about these proceedings today is that they're a mere summary process, and they do not provide due process of law. Period. Because the due process of law is you ask for remedy, rebutting their facts with truth. If they refuse that, then you ask for cure and relief, again rebutting their facts of law, or their facts with truth of law. And if they still do it, then you inform them that you're the live man, and you require a remedy, under ecclesiastica or ecclesia. And those are basically your three jurisdictions right there. Remedy is your maritime, cure and relief is admiralty, and Remedy as a live man is your ecclesiastical. So you have maritime, which is your contract laws, your all caps United States, all caps birth certificate name. United States capitalized first letter is your state citizen, which is the second half of your dual citizen, and that is the admiralty. That's where the states have their nationality independently from the federal government as a nation states. Then you have your ecclesiastical jurisdiction, which is your live man, again, which is antecedent to the formation of any state, religion, commercial entity, or anything like that. So when we talk about these powers, again, back to the 10th Amendment, when we talk about the powers of the state, the United States, the church, and the people, they're all separate. They're all different. The church has privilege. The United States has privilege. And the state has privilege. But the people have liberty of rights. Period. I hope you guys understand this. If you have any questions, please ask. I have no problem answering any question. If I don't know the answer, I do my research. So, again, thanks for listening. If it weren't for you guys, I wouldn't be doing this. God bless. Love you. Have a great day.